And this is breaking news coming in. A three-judge bench headed by the CJI modified the earlier decision of the two-judge Supreme Court bench. This is pertaining to the dowry law. Directions regarding constitution of welfare committee in 498A complaints has been withdrawn by the top court among other directions. Meenakshi Bhanja joining us now for more inputs here. Yes, Meenakshi.
This is a judgment which will have far-reaching implications, and the Supreme Court again intervening in its own earlier orders and course-correcting, so to speak, because this dilution of the dowry law, which is essentially Section 498A of the Indian Penal Code, had come in for some sort of concerns earlier when in September 2017, a two-judge bench of the Supreme Court in the Rajesh Sharma versus State of UP case had directed that each complaint of cruelty to a woman by a husband or a relative that does not involve the tangible physical injuries or death shall be first referred to the Family Welfare Committee of the respective district. This judgment essentially was based on the premise that Section 498A of the IPC has the potential to be abused by some women. Now, this was a judgment which the Honorable Chief Justice of India, Deepak Mishra, did not agree with, and therefore today a superior bench combination comprising three judges headed by the Honorable Chief Justice of India have gone back and remodified the 498A dowry law provisions to its original stringent provisions, and they felt that they needed to modify the earlier two-judge ruling of the Supreme Court because they felt that taking away or diluting any provision of the dowry law would impact the rights of women. Uvishi.
Right, Meenakshi, if you could also, for our better understanding, just throw some more light on the earlier judgment by the two-judge Supreme Court bench, which has been modified by the three-judge bench today.
Well, indeed, Ushi, the earlier judgment of the Supreme Court came out in September 2017, and that judgment of the Supreme Court was based on the premise that 498A, or the dowry law provision of the Indian Penal Code, has the potential to be abused by some women, particularly to harass the elderly in-laws. The Supreme Court, in that earlier judgment, had also cited some National Crime Record Bureau data in support of its judgment. However, the Supreme Court's later CJI-led bench combination was not in agreement with this finding of the earlier two-judge bench, and it felt that diluting the dowry law in any way would curtail the rights of the women, and subsequent to which the three-judge superior bench combination had called upon itself the re-examination of the earlier judgment. And just a short while back, moments back, as a matter of fact, Vishi, the 498A provision of the Indian Penal Code
Right, Meenakshi Bhanja there getting us the latest there on the update on the dowry law, which the three-judge bench that was headed by Chief Justice of India has modified the earlier decision of the two-judge Supreme Court bench. The dowry law has now been restored back to its original stringent provision. That's the latest coming in there.